by people said to be abductors. He was taken to a house where he was chained, tortured, and subjected to inhuman and degrading treatment. He was denied basic necessities, including food and water. He was rarely given water to drink or bath and was denied medication despite requests. After 8 days in captivity, on 27th June 2021, Mr. Nnamdi Kanu was driven to Jomo Kenyatta International Airport, put on a plane, and smuggled out of Kenya to Abuja, Nigeria, arriving in the evening of the same day where he was detained at the Nigerian National Intelligence Agency headquarters without extradition order. That's also a fact. Without, the court is now establishing all of the presented evidences now. You follow? Right. According to the petitioner, on 29th June 2021, the Attorney General of the Federal Government of Nigeria addressed a press conference and revealed that Mr. Nnamdi Kanu had been rearrested through the collaborative efforts of the Nigerian intelligence and security services so that he could be tried for the charges he was facing before disappearing while on bail. It was on that basis that the petitioner stated that Mr. Nnamdi Kanu believes that having been allowed to enter the country and being in the country lawfully, the government of Kenya had a duty to protect him, but failed. The respondent's position was that they were not aware of the claim that Mr. Nnamdi Kanu had been arrested or abducted, detained, incommunicado, tortured and taken out of the country to Nigeria. They denied that the government of Kenya was responsible for Mr. Nnamdi Kanu's transfer out of the country. The respondents maintained that there were no extradition proceedings to justify the government of Kenya's responsibility in Mr. Nnamdi Kanu's extradition. There is no OB record from any police station in the country to show that he had been lawfully arrested and detained for purposes of extradition proceedings. According to the respondents, since July 2019, Mr. Nnamdi Kanu had entered and departed from Kenya on several occasions, and his last date of arrival was 12th May 2021, and there was no evidence that he left the country this time. The respondent took the view that the petition is based on hearsay because there was no evidence that Mr. Nnamdi Kanu was declared a prohibited immigrant under Section 33 of the Kenya Citizenship and Immigration Act, or that a deportation order was issued under Section 43 of the Act. The depositions in the affidavit were made by persons who did not witness the events complained of. The respondents maintained that the East African tourist visa issued in Kigali, Rwanda was valid from 13th March 2021 to 11th June 2021, and therefore it was not possible for Mr. Nnamdi Kanu to be in the country on the same visa on 19th June 2021. Now, the respondent's position was that the petitioner had failed to show that it was Kenyan police officers who arrested Mr. Nnamdi Kanu, or that it was in the custody of the authorities in Kenya. It's a covert operation. They didn't declare him publicly. It was all illegal. So what were they thinking? So they are now doing the plausible deniability. I'll be waiting to record that thing. Let's just deny it. But I think the court could see it through them, if you probably ask me. Anyway, the undisputed facts in this petition are clear that Mr. Nnamdi Kanu entered Kenya lawfully on an East African tourist visa from Kigali, Rwanda, and stayed in the country for some time. The respondents admitted this fact, stating that his last arrival in the country was on 12th May 2021. They also stated that there was no evidence that he had left the country. The respondents admitted, therefore, that there was no record of Mr. Nnamdi Kanu Mr. Nnamdi Kanu's lawful exit from the country. The respondent's position, again, that there is no record that Mr. Nnamdi Kanu had left Kenya seems to give credence to the petitioner's assertion that Mr. Nnamdi Kanu was abducted while in Kenya and taken out of the country. If that be not the case, the question then is, since Mr. Nnamdi Kanu entered the country lawfully on 12th May 2021 and had not left Kenya, where is he? Mr. Nnamdi Kanu, having entered Kenya lawfully, he had the right to remain in the country for the period his visa allowed him to stay. And in the event the visa expired, he knew what to do to extend his stay in the country while in Kenya. Mr. Nnamdi Kanu enjoyed the protection offered by the Constitution and laws of Kenya. He was also subject to the laws of Kenya in the event he committed a crime. His presence in the country was indeed acknowledged by the respondents. The petitioner pleaded, averred, and deposed that Mr. Nnamdi Kanu was abducted on 19th June 2021 at Jomo Kenyatta International Airport by people said to be security agents from Nigeria and detained incommunicado for 8 days in a house in Nairobi. He was there after taken to Jomo Kenyatta International Airport and put on a plane to Abuja, Nigeria. On arrival, he was taken to that country's intelligence services agency headquarters. The respondents, of course, denied being aware of the alleged abduction or that Kenya was involved. The respondents again maintained that, indeed, Mr. Nnamdi Kanu arrived in Kenya on 13th May 2021, but there was no evidence that he had exited the country. So what happened? So the judge continued, or the judgment continued. The respondent's assertion that there was no evidence that Mr. Nnamdi Kanu had left the country would imply that he was still in Kenya. If that were the case, the respondent had the ability and means to find out where Mr. Nnamdi Kanu is. Prince Kanu deposed that he met Mr. Nnamdi Kanu on 27th July 2021 at the Intelligence Security Services headquarters in Abuja, Nigeria, where Mr. Nnamdi Kanu was being detained, and gave him information on how he was abducted and taken to Nigeria. The information deposed by Prince Kanu corresponded with what the petitioner stated in the petition on how Mr. Nnamdi Kanu drove to JKIA, Jomo Kenyatta International Airport on 19th June 2021, only to be abducted while at the airport precinct. The petitioner gave details, including the time Mr. Nnamdi Kanu was abducted. Jomo Kenyatta International Airport is a high security area, and nothing can happen at the airport without being detected. If the respondents had interest to know what had happened, they would have known. The respondents, one of whom is the Cabinet Secretary for Interior, another officer commanding police station at Jomo Kenyatta International Airport, and the Attorney General, the principal legal advisor to the national government, would know what happened at country's premier facility if they wanted to. However, even with the averments and the position that Mr. Nnamdi Kanu was abducted while at one of the most secure facilities in the country, all the respondent could say was that the depositions were hearsay, while admitting that Mr. Nnamdi Kanu entered the country, but there was no evidence that he had left or exit from the country. Man, I actually love this Kenya. I mean, you know the film? I think I kind of like this Kenya because, listen, Kenya judiciary. Give me a sec. I'll see if I can come bigger so I can come closer to your screen. Kenya judiciary, right? I'm not saying maybe they are not corrupt or what have you, but you know that every time I hear that or I kind of like read about them in the media, it's always so positive. It's about something that they are standing up against the system. When this Gen Z decided to protest I'm sorry to just avert a bit, okay, to deflect a bit, right? So I'm talking about their judiciary, right? Kenya Supreme Court stood behind the protesters in Kenya when Ruto was out there to kill and crush the protesters who are protesting the finance bill that last year. Yeah. They expected, they arrested a lot of people, took them before the court, and court released all of them. All of them. And at the same time, they wanted to declare that a protest is illegal. The Supreme Court of Kenya came out and said, no, it's not. Let them express themselves. So when you now read the way this judgment is delivered, if you are reading like I am right now, I mean, you're going to agree with me that the wordings, which is the reason why I'm actually reading this, the wordings, the way they worded their judgments, Baba, you go no say, there is a certainty that you can get justice. That is not the contraption in Nigeria. Not that you don't have good judges in Nigeria, but they are corrupt enough that in a situation like this, they will be on the side of the criminal government. Yeah? Because how could you say somebody entered your country? Everybody knows that nobody can just pick a passport and go to anybody's country. And once you enter any country that you are a visitor, they know where you are. Some countries even have visas that you see at the port of entry, right? They can know who you're looking. America does that though. Like they will know wherever you are, everywhere you go to in that country, you are being tracked, they know you. How can you now go to the front of the court and say it is a hearsay that you don't know where this person is? So if you say this person hasn't left Kenya, he entered Kenya, but he hasn't left Kenya, then you have, they found him in Nigeria. And these criminals in Nigeria, they are thanking you that they work with you to abduct him illegally. No paperwork, no nothing. They took him to Nigeria. And all you could put up, your lawyer could put up in front of your own judge is to sound so dismissive and stupid as well. Like if you have been following the reading since, they call them responding. They are like being so like, but you know what? Let's continue. Okay. So the judgment will continues. I have read the affidavit sworn by Prince Kanu, a brother to Mr. Nnamdi Kanu. He deposed that he met Mr. Nnamdi Kanu in Abuja, Nigeria, where he was being detained. Mr. Nnamdi Kanu told him what had happened and how he was abducted from Nairobi, Kenya by Nigerian security agents and taken to Abuja, Nigeria. Prince Kanu deposed to facts as told to him by Mr. Nnamdi Kanu, who was being held in detention and could not therefore swear his own affidavit. In other words, the facts deposed to by Prince Kanu were on information given to him personally by Nnamdi Kanu himself. In that respect, the fact deposed in the affidavit could not be hearsay. The petition was also forthright that on 19th June 2021, at 12 noon, Mr. Nnamdi Kanu was taken to Jomo Kenyatta International Airport, put on a plane and taken to Abuja, Nigeria. Arriving in the evening of the same day, the petitioner's position, just like that of Prince Kanu, was that Mr. Nnamdi Kanu exited Kenya through Jomo Kenyatta International Airport after he was forced onto a plane and taken to Abuja, Nigeria, where he was detained. From these facts, there can be doubt that just like no one can enter the country through Jomo Kenyatta International Airport without documents or being detected, no one can depart through the airport, Jomo Kenyatta International Airport for that matter, without documents and or the knowledge of those responsible for the security of the airport and board a plane without being detected. The respondent did not dispute the fact that Mr. Nnamdi Kanu was taken out of Kenya through Jomo Kenyatta International Airport. Their position was that there was no deportation order. There was no record at any police station showing that he had been lawfully arrested and that the government was not responsible. The abduction and incommunicado confinement were not lawful acts, and therefore, there could be no record on acts not sanctioned by law, given the respondent's admission that there was no deportation order in respect of Mr. Nnamdi Kanu. I find and owed Mr. Nnamdi Kanu, having not left the country voluntarily, he was forcibly removed from Kenya, and that is why there is no record regarding his departure or exit from Kenya. So, violation of rights. The next and most important issue is whether Mr. Nnamdi Kanu's rights were violated. The petitioner argued that Mr. Nnamdi Kanu was abducted without warrant and kept in a secluded house within Nairobi, where he was chained, tortured, and treated in an inhuman and degrading manner for 8 days. During the period, Mr. Nnamdi Kanu was denied food, water, and access to medication despite his health condition. The respondents denied knowledge of these acts. Mr. Nnamdi Kanu, having entered Kenya lawfully, was subject to the protection guaranteed by the Constitution and laws of Kenya. It was to be treated as required by the Constitution and laws of Kenya, since his rights were recognized and protected by the Constitution, and in particular, the Bill of Rights. It is in that respect that Article 19(2) of the Constitution provides that the purpose of recognizing and protecting human rights and fundamental freedom is to preserve the dignity of individuals and communities, to promote social justice and the realization of the potential of all human beings. Clause 3 thereof is also clear that rights and fundamental freedoms in the Bill of Rights, in quote, belong to each individual and are not granted by the state, and, again, in quote, are subject only to the limitations contemplated in the Constitution, of quote. I love this, right? Article 21 states, even more succinctly, that the Bill of Rights applies to all law and binds all state organs and persons, and that, too, every person shall enjoy the right and freedoms in the Bill of Rights to the greatest extent consistent with the nature of the right of fundamental freedoms. The Constitution is clear that the Bill of Rights binds not only state organs, but every person within the territory of Kenya. In that regard, Mr. Nnamdi Kanu's rights were recognized and protected by our Bill of Rights. He had the right to enjoy those rights and fundamental freedoms to the greatest extent possible while in Kenya. I love this.
Oh, you do I call. Oh, Mary, Abakare, Mama Baora, Unapuri Mary Nnamdi win the war. Python that's 1, Python that's 2, now Python that's 3. Unapuri Mary Nnamdi win the war. Python that's 1, Python that's 2, now Python that's 3. Unapuri Mary Nnamdi go onye du aimo o meri woni nizu ngiro ya Abakare mama ndawora unapuri Mary Nnamdi win the war. Python that's 1, Python that's 2, now Python that's 3. Unapuri Mary Nnamdi win the war. Python that's 1, Python that's 2, now Python that's 3. Unapuri Mary Nnamdi win the war.
Bless you. Let's continue. The import of the above constitutional provisions in so far as the petition is concerned is that they fully applied to Mr. Nnamdi Kanu to the full extent as soon as he entered and remained within the territory of Kenya, whether lawfully or not. He was to enjoy his rights and fundamental freedoms and was to be treated fairly and justly as required by the Constitution and the law. If, for any reason,